Good evening. Welcome to Life Ahead right here on PBS Fort Wayne. I'm Sandy Thomson, the host of the show, but our real star you're going to meet in just a moment. If you haven't watched before, if you have, you'll know him. Bryan Nugen is an attorney specializing in elder law, and he comes to see us about every month and shares a lot of information. Here he is, right here. See, you'll recognize him, right?
Hi,
Bryan,
everybody. Hi, Sandy.
Thank you.
Thank you for having me. I really appreciate it.
Well, you know, I've learned a lot from you, and one of the things, and then I try to remember. So if I'm out just having a casual, conversation with other people, I can work in those legal terms and pretend I know.
Good for you.
But
That's
you're
great.
going to teach us some new stuff tonight.
Well, we'll see. I hope so. Yeah.
Well, we're going to let's first talk about some of the basic terminology.
Okay.
Just to very quickly go over it, and I know we've talked about this before.
Sure.
You call documents like your will and testament, your power of attorney. You call them instruments.
I'll say instrument because I think that using the word document kind of downplays how important those items that you're signing, those instruments are. And so I want to give it the weight that it deserves, and they're important instruments that we use.
Are you the only one, or do all attorneys use that?
I hear other attorneys using that phrase as well.
Okay.
I think that sometimes, I was just having a conversation earlier today about folks were saying they had heard another professional suggest printing documents off online. And so I think that it doesn't necessarily, maybe folks think that sometimes when you have these items that you're signing, these instruments that you're signing, it's a cookie cutter approach and everything is the same, and it really isn't.
Yeah.
So if we're talking about legal instruments, I think it gives it a little bit more weight and makes people think about it a little bit more than I want a document printed off and I can fill in the blanks, and it may or may not be appropriate for
Date
them.
it and sign it.
Yep.
Well, you mentioned it, so I'm going to ask you to expand on that a little bit about printing things off the internet.
Yep.
I bet you have clients that come in with a copy or tell you, I printed on. I already did my will. I did it online. What do you think of that?
Well, it's a very great question, first of all, because I do get those questions, and I'm sure other attorneys get those questions as well. We found this online. We don't need that. We've already done it. Do you think that's okay? Well, until your attorney has reviewed that instrument, it's difficult to express an opinion about whether it's a good thing or not a good thing. I will also say that every person is unique. What they want and what they want to get accomplished is unique. And so each one of those instruments that you're signing should be uniquely prepared for you. And because it was right for a neighbor or it worked one time doesn't necessarily mean that that's one that you're going to want to be using regularly. It may not be as robust as you need it to be. Even powers of attorney. We talk about powers of attorney, and it seems very basic that you could sign that.
Yeah.
When we're talking about elder law and we're thinking about protecting assets, we're thinking about wanting to make sure that that document is robust as it can be. I'm saying now, document, that instrument is robust as it can be. We want to make sure that certain language is in there so that if someone needs to talk to FSSA, Medicaid, they can talk to them on your behalf. If we need to transfer funds, we're permitted to transfer funds by that instrument. So something as simple as you're thinking, power of attorney, that's very standard. It isn't necessarily standard. Healthcare representative designations. So you're appointing someone that can make decisions on your healthcare if you become incompetent or incapacitated. Very, very important things. So I don't know why somebody would risk that and having those things done properly. And it is true, although there are pro bono services that do some of these things for clients, sometimes just a little bit of money is well spent to make sure you have a very solid foundation.
Might save you money in the long run, because if it's not complete, or in your words, robust, I want to talk about that
like
word
that?
too,
Right.
you might have to spend more money sorting it out legally.
It's not necessarily even the money. It's just that what is it that you're wanting to get accomplished?
Oh, maybe.
And does this instrument allow me to get accomplished what I need to get accomplished, what I want to get accomplished? So I think of that even beyond the powers of attorney, healthcare representative designations, HIPAA waivers, wills and trusts.
Right.
People will, again, like you're saying, Sandy, find those instruments online, pull it out of a book, and it is frequent when we review those, that we see that it wasn't signed properly, we didn't have the witnesses that we needed, language isn't properly drafted, so it is doing a disservice to the client for them not to have something put together that's really
correct.
solid and correct. And this is your life savings. This is your creating a guardianship for your minor children,
Yeah.
possibly, creating a trust for your minor children, passing wealth to your children, to your
Yeah.
grandchildren, whatever it may be. So sometimes to have a professional review those documents with you is good advice, and it's appropriate. And of course, this is the industry that I'm in, along with other elder law attorneys and estate planning attorneys, but we would want them to have appropriate things in place, and
Sure.
we want them to be able to achieve what they want to achieve. If we're avoiding probate or avoiding a taxable event, we want all of that to be in those documents.
Somebody aligned that topic or situation once to, okay, I need to buy health insurance and life insurance. I'm going to go to a kiosk in the mall.
Yeah, that's a good analogy.
You
Right.
know.
So you would want to speak with your the agent. You would want
Yeah.
to make sure that you're appropriately insured. You have the appropriate coverage. If it's for your home or for your health insurance, whatever it may be, you would want that. You would seek out the advice of a professional. So I would
Robust.
encourage your listeners to seek counsel of their choice and get those things in place.
Okay, you said you used the word robust. You want to make
Yep.
sure that your instruments or documents are robust.
You're not
what
making
does
fun
that
of me, are you?
mean? Oh, of course not, Brian. I would never do that.
Good. Well, when I say robust, what I mean is that it really is appropriate for you and what you want to get accomplished. It's well written. It's succinct.
Complete, has everything in it.
And you're thinking it through. So, for example, if we have a special needs event in the family, meaning when someone is inheriting the money, if they're a special needs person at that time, so a grandchild could be special needs, it could be that someone's had an accident and they become special needs at some point in
Yeah.
the future, a loved one has a dementia. If they're inheriting directly, that could affect the benefits that they're receiving at that time. So if we put special needs language in our wills, in our trusts, we're able to, for them still to inherit the money, but for it to be protected, and they don't lose any of the benefits that they're receiving. So when we talk about them being robust, it isn't as simple as one page that says this goes to this person, that
Yeah.
goes to that person. There is much more language that we use in those instruments to
Yeah.
make sure they are robust for
I
that
love
person.
that. See, now I'll use that word.
Drafted properly, of course. And we're achieving what they want to achieve.
Right.
And a healthy conversation with your legal professional is going to help you really ferret out what's appropriate. And
Because you might not think of some of the things yourself.
it isn't what you know, it's what you don't know. And you're having that conversation, and hopefully the professional that you're working with is giving you guidance and making some suggestions.
Yeah.
And what if this, then that? So for an individual doing their estate planning or working on an elder law matter, it wouldn't be uncommon to have more than one appointment with your, with the attorney that you're working with. So you shouldn't be intimidated to have that conversation. I think typically, counsel in this area is very interested in engaging with their clients. They have an affection, an affinity for this type of work, and they'll spend time with you and for you to have a good experience with it. And generally, this type of work is flat fee based. So typically, if you're
Flat fee?
flat
Okay.
fee. So if the client was speaking to the attorney, 2 times or 3 times for it to be finalized, they're not necessarily being charged on an hourly basis for all of that work. It's typically there's a flat fee that's involved with it.
Per instrument or per document
per
or
instrument,
what?
could be for a certain
Situation?
set of instruments. But my point is, sometimes people have a concern that if I speak to the attorney, I'm going to be, every time I call them, I'm going to be charged. And there are types of matters that attorneys are representing you in which their work is charged in that way, and it's appropriate. But typically in estate planning and elder law matters, it isn't necessarily charged on an hourly basis. Generally in our industry, it's a flat fee that's quoted for that type of work. So that should give your listeners comfort that they know. Even if I meet
no
with
surprises.
No surprises. Even if I meet with my attorney 2 times or 3 times, however long it takes, they shouldn't be worrying. Oh, every time I'm speaking with them, I'm getting charged more.
Yeah,
and more.
tick, tick, tick,
No.
dollar
Yep.
signs. But it may be different from one attorney to
yes.
another. So if somebody tells you,
I'm saying
it costs this much.
generally in this industry, it's typically flat fee for that type of work.
Oh, is it?
But you are right
Okay.
that there are attorneys that may charge on an hourly basis for that type of work. But I think generally, and this is very broadly speaking, the listeners, if they were speaking with folks in this area, they should expect to see flat fees.
Okay, let's talk about this area then and
Yeah.
this timing. Does it change, Bryan? I mean, do you guys get together every year and say, "Oh, let's
Well-
all go up 3%," or does
Yeah.
inflation make any difference in
Well,
charges?
I'm not having a discussion about how much attorneys would be charging. I'm just saying generally that's what clients should expect
Okay.
if they're speaking with counsel. So no, attorneys don't speak to one another about how things are being charged. It's a quality of the work and
Yeah.
But you mentioned a point about getting together. I thought you were going to be talking about continuing legal ed. So yes, attorneys have continuing legal education in their field of interest.
How does that work? Do you go somewhere? Or there,
Sometimes it's in person and sometimes it's remote.
is it local or national conventions or?
Both. Yeah, tomorrow I happen to be in a CLE for 2 days in a row, and it is all remote. But I, in August, was at a CLE where it was all in person. So it depends what you're
Yeah.
selecting. I think with the advancements of the internet,
Sure.
you're seeing more remote, and it's more a standard thing than it was at one time. At one time, everything was in person, and that's different state by state. Each state would be different what they do and don't permit for remote education. Sometimes they'll have a mix of some remote, some in person.
Are there state organizations for attorneys?
There are state organizations.
Do
Yeah.
they organize these?
They do, and it has to be approved by the state.
Okay.
Each state has a different approval process. Each state has different requirements. So Ohio, let's say, may have a substance abuse class that you need to go to every 2 years, but India may not have that. So
Yeah.
it is different state by state. Florida has a technology class you have to attend. So it's different. Sure, every state is different.
Well, a lot of professions might require you to update or redo your certification for something. I don't know, maybe you have to redo CPR every year, or you have to do something to renew your license. Do you guys have to do anything like
So
that?
it's not a license renewal, but it is those number of classes. Within a 3-year period, you have to have a certain number of hours and turn those into each state in which you're barred.
Well, that's comforting to know.
Although I will say, Michigan, interestingly enough, Michigan does not require ongoing continuing legal education
Oh
classes.
my, really?
Yeah. Some states do, some states don't. Most do. I would say majority do.
Then I'm not going to Michigan for an attorney. That's it's interesting.
Yeah.
Very interesting. Okay, let's talk about some other terminologies.
All
And
right.
you've mentioned a little bit of it, but
Yeah.
probate. Explain what it is, and do we want to do probate, or
Sure.
do we want to avoid probate?
Well, I do think that people will frequently say, "Oh, I want to avoid probate." Well, probate is the process whereby you have a last will and testament, you file it with a court, or if you didn't prepare a will and you don't have beneficiaries on your assets, we are opening an estate with the court. So probate
You're
is
opening the estate with
an estate with the court.
Oh, with the
that's-
court,
yeah,
okay.
that's the process whereby you file your will, or if you passed without a will, we go through something called intestate succession, where the state statutes indicate where the funds go. So probate is the process where you file something, you open the estate. Normally there's an advertisement in the newspaper saying the person's passed away. So if you have claims to be made, if you are someone that says, hey, this person passed away and they owed me money, I can file a claim in that estate for me to be paid out of the estate funds.
Bryan,
Yeah.
just to interrupt for a moment, is that required to put something in the paper or not?
It is
I've heard
required.
both.
No, it's required. And so there are certain instances where if you're going through probate, to realize there are many ways to pass assets when you pass
Okay.
at the time of your death. But if we're going through probate, the answer is yes. You have to publish in the newspaper. If you're circumventing probate because you have a beneficiary designation, or you've done something like a transfer on death deed, or maybe you've used a trust In those instances, for those assets, you may not need to publish in the newspaper indicating that the person has passed. There are time periods within which folks that are owed money have the ability to open an estate for you in order for them to be reimbursed. That is possible. There are deadlines on doing that. If an estate isn't opened in a certain time frames based upon different types of creditors. I'm getting too complicated now. But if the estate isn't open during that time, then they lose the right to be able to file a claim in the estate. But yes, if we open an estate, we go through the probate process where we request the court to appoint a personal representative. We're advertising in the newspaper. We're opening that estate. In that instance, yes, we do have to file something in the newspaper.
Well, I'm going to ask another what-if question.
Okay, I'm ready.
Okay, so you always are. You always take any question I give you or callers, and you can call us still here for the next 10 minutes or so, 969-2720, if you have a question for Bryan. Okay, so required to put something in the paper in case you have somebody that you owe money to and they can, you know, send their invoice in. What about if you just die? I mean, that sounds terrible.
Without a will.
Do you no, with or without? Do all obituaries have to be in the paper?
Well, it's not an obituary. So I'm not referencing an obituary. I'm referencing it's a legal notice that someone has passed.
I know.
And the state has been opened.
Besides
you
that,
don't need to put. You don't have to put an obituary in the paper.
Oh, okay.
If you don't
I've
want
heard
to have
both.
One.
That yeah, you
I'm
have
not aware
to.
of a requirement that you need to.
Okay.
Put an obituary in the paper.
I think I heard that like you're charged by the line or something like that.
That could be. That maybe for your next speaker.
It's another topic, another day.
Yeah, maybe a funeral director would be better.
Well, I'm just curious because so many things have changed, you know, in society and with the internet. And I'm always wondering, like these creditors that you're publishing your passing to. What if they never read the paper? How are they ever going to know?
Well,
not everybody reads the paper every day anymore.
That's true, but it generally, so your state statute will indicate in every state in which a probate matter is being opened, the state statute would indicate how you publish notice to the world.
Okay.
Typically, that's in a newspaper, and it's a local circulation, a paper that it's generally circulated in that community where you passed. Yeah. We're still publishing in the newspaper. Unfortunately, the newspaper is not as popular as it once was. I know circulation is down, but that's still our process and procedure.
I mean, somebody can't come back to you and say, "Well, I didn't know. We don't get the paper, so you can't." You know.
When you open an estate and you go through probate, you actually, with the court, you're filing proof that you filed, or you published that in the newspaper. So you couldn't close the estate without having verification filed with the court that in fact there was a publication in the newspaper and it was done properly. Even in the notice, we reference the state statute, we reference all of that in the notice itself. So if you read the newspaper, you're going to find those notices in there. And one of the reasons people use trusts actually is so that they don't have to publish in the newspaper.
Oh, you don't if you have a trust?
You avoid probate process.
Well, let's talk about
assuming
trust.
It's properly funded. And when I say a trust is funded, meaning I put real estate into the trust, I put a brokerage account into the trust, my checking account, my savings account is in the trust. So assuming that trust is properly funded, we have assets in it.
Yes.
Whatever's in that trust, it goes to your ultimate beneficiaries. So whoever it is that you've indicated at the time of your passing who receives the wealth, that's where the money goes. So your trustee, a trustee is like a manager of that trust, the assets in the name of that trust. So it's the manager's duty, the trustee's duty to distribute it to grandkids, charity, religious organization.
Whomever is in your document or instrument.
Instrument. Thank you.
Okay.
Yeah, you'll not forget that.
Because the instrument's going to be very robust. Okay, so with the trust, and again, you have, you have all those specific things of what you want. What if you don't have something in a trust and you don't have a trustee? Who handles all the finances?
So this goes back to if you have a will, we open an estate, your personal representative, your executor is the one that handles that.
Okay.
If you didn't do anything, if you didn't prepare a will, we go by state statute, and state statute indicates where the money goes. So it would go to, some to your spouse, some to your, it depends if it's first spouse,
Is it
second
different
spouse.
for every state?
Yes, every state does have different intestate succession statutes. However, yes, I should say, they are different. Generally, it's staying within the family, but if you're not an Indiana resident, you're an Ohio resident, it's going to be a different process. If you're a Florida resident, it's going to be a different process. If you're an Illinois resident, it's going to be a different process.
Well, and everything is just so different nowadays anyway. I mean, as compared to 25, 50 years ago, now there are more blended families, and it just is more complicated.
Sure.
We have a question for you, Bryan.
All right.
What are the conditions in which you would need a trust? Good question.
Thank you,
and
Dorothy.
that's coming in from Dorothy. Thank you, Dorothy.
Appreciate it. Well, I think what's important, Dorothy, is to know what it is that you want to get accomplished. And trust is a giant category. Don't be overwhelmed by the word trust. Sometimes people are intimidated by that. A trust is just a contract. You've signed lots of contracts in your lifetime, and inside that contract, you've generally got three players. You've got the settlor grantor, that's the person that made the trust. You have a trustee, that's who's the person who's managing the assets in that trust, and beneficiary, who can benefit or enjoy the money in that trust. So depending upon what you want to get accomplished, if you're just worried about avoiding probate at the time of your passing, you don't want the attorney fees that are associated with going through probate, you want to speed up the process of getting those assets out, you want to keep it private, you may use something called a living trust. That's very common. If we are looking at a trust to protect assets during our lifetime from liability, if there's a special needs person in your family, if you want to stretch a grandchild getting the money over time or a child getting the money over time, we would use a trust. If we were
Because you could even specify they get so much when they're 18, so much at 25.
You dream it up and it can be drafted.
Okay.
So you can do trusts for pets. You can do trusts for charitable entities. You could do create a trust to benefit PBS. You could do
We
any
like
of that.
yeah. And some people do that.
They do that.
Yeah, which is
For sure.
wonderful. From what I understand from legal conversations we've had, Bryan, I understand that a beneficiary, if you've named a beneficiary on an IRA or a bank account or anything, that is overrides anything you put in the will?
It does. So back to what we were talking about before. Let's say that you were charitably inclined.
Yeah.
And you wanted to remember PBS, and you said PBS is going to get 35% of my estate. And you're thinking, 35% of my estate is going to go to PBS. That's what I wanted to do. I'm charitably inclined. Then you have an account at the bank, and on that account, you've indicated this account goes to my oldest child because I know that my oldest child will give the money to siblings, will give the money to PBS, whatever it may be. That beneficiary designation actually gives all the money to the oldest child. They can do with it whatever they want to. They may end up giving it to PBS. They may end up giving it to the other siblings if that's what you want, but they may not do that.
But it overrides what your will said.
It overrides anything you've written in your will. It overrides anything you've written in your trust. So beneficiary designations seem very simple, but actually they're very powerful. And you want to make sure that the beneficiary designation is appropriate and it addresses those things that you have in your will, addresses those things that you have in your trust. Sometimes on an asset, we may indicate that the estate is the beneficiary or the trust is the beneficiary. So if we have qualified money like IRAs, 401ks, sometimes the trust is actually the beneficiary to receive that money and then for it to go out to children, charities, religious organizations, etc.
Okay, would you speak to revocable and irrevocable trust?
Revocable, it's as the name implies, you can change it at any time. It's like putty. I write it today, I want to change it tomorrow, I can change it tomorrow. Irrevocable is permanent in nature. Generally, those cannot be modified without certain events happening. But you should think generally, revocable, I can change, it's completely accessible to me. Irrevocable, set in stone, can't be changed, it's more permanent in nature. Trusts could start as revocable and end up converting to irrevocable. In events where if someone were to become incompetent, it could convert. At time of passing, a revocable trust would be irrevocable at that time and pay out to whoever you've indicated.
How would you recommend, or what would you recommend in terms of like going over all of your documents? How
frequently?
often? Every year? Every
No,
5 years?
Yeah, 5 to 7 years, I think. And it's interesting, when you review your documents, you may say, oh, I forgot we have done this. Or there's a change in someone's health in your family.
Yeah.
Your children have moved, been married.
Yeah.
So I say every 5 to 7 years.
Because life just keeps changing.
It does change.
And that's why Bryan keeps coming back to give us all the updates legally. Bryan Nugen, thank you,
Thank you,
so
Sandy.
much.
I appreciate it.
always learn things from him when he comes, and I try to remember him for the next time. Thank you all for watching tonight. Dorothy, thank you so much for your phone call this evening and for watching us here on Life Ahead. We'll see you all back here next Wednesday night at 7:30. Good night.
The preceding program on PBS Fort Wayne was made possible in part by
Nugen Law, focusing on estate planning and elder care law, emphasizing independence and quality of life. Serving Indiana, Ohio, Michigan, and Florida. More information at nugenlaw.com.